This is volume 117 of the Mars Hill Audio Journal. I'm Ken Myers. Many years ago, while working for National Public Radio, I attended a seminar on the question of government support for the arts. One of the participants was conservative columnist George Will. Will wryly observed that when a government takes steps to protect or preserve or prevent some activity or condition, it first has to define the thing in question. So when a government decides to protect wetlands, it has to define what a wetland is, what qualifies a certain space as a wetland. So it was, Will said, with the arts. If citizens believe that the government should provide public support for the arts, then some agreed-upon definition of what constitutes the arts or a work of art would be necessary. George Will observed that very few artists would be happy with the prospect of some government bureaucrat or a group of legislators defining what constitutes art. But unless people were willing for the government to define what art is, then they can't expect the government to support it. A wetland is a natural phenomenon. It's a component of a natural system, something that plays a role in conjunction with other natural processes. A wetland is definable, and its value is ascertainable by observing the ecosystems in which it plays a role. George Will's objection to government funding of the arts seemed to be based on the assumption that the public could only agree on the definition of something if scientific knowledge was available, science being the means by which we identify public knowledge. Since the qualities and value of art were not scientifically verifiable, government couldn't locate where art is and hence shouldn't be expected to support it. But governments do protect things that are definable apart from science. Justice, for example, or freedom, or human dignity are not purely scientific realities. That doesn't make them entirely open to any definition that we want. Any given act is not regarded as just or unjust simply because a majority of voters says it is. While defining justice may be harder than defining a wetland, it's neither impossible and nor is it purely subjective. George Will was correct in insisting that the making of laws and policies requires an effort of definition. But there's more than one method of defining the realities with which laws are concerned. Just because something can't be defined by science doesn't mean that it has no intrinsic meaning. In many matters that involve government action, the work of definition is somewhere between purely scientific calculation and arbitrary democratic declaration. In the current political debate concerning same-sex marriage, there's been very little public discussion of the definition of marriage. On the very first page of a book called What is Marriage, the authors write, quote, "What we have come to call the gay marriage debate is not directly about homosexuality, but about marriage. It is not about whom to let marry, but about what marriage is." Close quote. The book, What is Marriage, had its origins in an article in the Harvard Journal of Law and Public Policy written by Sherif Girgis, Ryan Anderson, and Robert George. George is currently visiting professor at Harvard Law School and McCormick Professor of Jurisprudence at Princeton University. I recently talked with him about the argument made by himself and co-authors in What is Marriage, and about the state of discussion about marriage in our culture. When we talked, the Supreme Court had recently heard arguments in two cases concerned with same-sex marriage, United States v. Windsor and Hollingsworth v. Perry. I asked Robert George for a summary of what these cases were about.
One challenges the constitutionality of the proposition in California that restored the conjugal definition of marriage as the union of husband and wife to California law after it had been invalidated by the California State Supreme Court. The other case is a challenge to the Federal Defense of Marriage Act, which defines marriage for purposes of federal law as the conjugal union of husband and wife.
And the Defense of Marriage Act was signed by President Clinton, but as I think you report in the book that President Obama has instructed the Justice Department not to defend it.
Yes, that is correct. It was passed in the 1990s during the Clinton years by large bipartisan majorities in the House and the Senate, signed into law by President Clinton.
Were there questions at the time about whether or not it was constitutional? Was that even imaginable, lo these few years ago?
Sure. There were activists on the left, people who believe in an understanding of marriage as essentially sexual romantic companionship or domestic partnership, and who reject the historic definition as the conjugal union of husband and wife, who were claiming that the Defense of Marriage Act was unconstitutional, not only for the provision that's currently under challenge, but also for the provision that protects the authority of individual states that retain the conjugal definition of marriage as the union of husband and wife, protecting their right to do that and not to be forced to recognize out-of-state same-sex partnerships as marriages. That is not, as I say, being challenged in the current case, but depending on how things go, it will very likely be challenged in the future.
Mm-hmm. And the other case, I think it's Hollingsworth versus Perry, is that right?
That's the Proposition 8 case. That's the challenge to the referendum by which the people of California restored to their law of marriage the conjugal understanding of marriage as husband and wife.
And are the points of law in the two cases different, or are they essentially the same?
They are the same in one respect and different in another respect. They are the same in that in both cases, those challenging the laws are making the claim that the Equal Protection Clause of the 14th Amendment to the Constitution of the United States essentially requires states to recognize same-sex partnerships as marriages. They're different in this respect. There is, in addition to that claim, in the Defense of Marriage Act case, the claim that the federal definition of marriage violates the right of states under our federalist system to determine what counts as marriage or doesn't count as marriage. So the claim there is that the federal government is bound under principles of federalism to recognize in federal law same-sex marriages from states that recognize same-sex unions as marriages, such as Massachusetts and now New York. Mm-hmm. That's a very, to my mind, very difficult claim to make creditable. Mm-hmm. But who knows? There's the possibility that it will be accepted by the Supreme Court of the United States. Justice Kennedy, in the oral argument, showed at least some possible sympathy for it, although the responses by way of criticism, the responses to it by Chief Justice Roberts were pretty compelling. And there are a number of scholars, even among those who want the court to strike down conjugal marriage laws and to require that same-sex partnerships be recognized as marriages. There are a number of scholars who nevertheless think the federalism claim is just too far a stretch.